The first time I heard the phrase community property tossed at my lake house, I was waist deep in the water pulling my kayak ashore. I turned around and saw her Brielle Redding, president of the HOA, standing on my dock like she owned the lake. "You're not authorized to fence off the dock," she said, arms crossed, sunglasses perched like a crown of entitlement. "This shoreline is part of the community's shared access. It's in the HOA bylaws." I blinked, confused. "What? No, it's not. This is my land, bought it last year. Had it surveyed, deeded, and recorded with the county. Nothing here is community property." Brielle scoffed and adjusted her sun hat. "You're mistaken. The HOA has always treated this area as shared space. You can't restrict access." That was the first shot fired. "I'm Everett Granger, retired paramedic, and I bought the lake house to get away from people like her. I didn't even know the property fell under an HOA until 3 weeks after I moved in buried clause in the paperwork from the previous owner. They called it Lakefront Meadows Association. Sounded more like a bed and breakfast than a threat to my sanity. Brielle showed up weekly after that, clipboard in hand, nitpicking everything from the color of my mailbox to the unauthorized fire pit I built near the waterline. But this was different. She'd crossed a line claiming my shoreline access belonged to anyone but me. A week later, I got a letter taped to my door. Not mailed, taped. Handwritten HOA notice, signed by Brielle and 2 board members, saying my dock and lake access were being reclaimed for community use, effective immediately. I laughed out loud. Then I called my buddy Marcus, real estate attorney. He didn't laugh. "That's not just overreach," he said. "It's potentially criminal if they're trying to seize private land without legal authority." I started documenting everything, every visit, every note, even installed cameras around the dock and house perimeter. I had a feeling this was about to get ugly. And sure enough, a few days later, I caught Brielle and her 2 board buddies on camera. They were unbolting the gate I'd installed at the top of my dock stairs. Middle of the day, didn't even try to be discreet. I came down the hill and shouted, "What the hell do you think you're doing?" Brielle didn't flinch. "You were warned. The HOA has voted to reassert community access. Your gate is a violation. That's private property," I yelled. "You're trespassing. Call the sheriff then," she said, smug as ever. "We're just enforcing the rules." So I did. Deputy showed up 10 minutes later. I showed him the deed, the plat map, and the footage. Brielle tried to talk over me. "This land has historically been shared." But the deputy shut her down. "Ma'am, unless you've got a court order saying otherwise, you need to leave his property immediately." Brielle's face turned red enough to match her manicure. After they left, I filed a restraining order and then filed for a declaratory judgment in county court to settle the matter once and for all. If they wanted a fight, I was going to give them one. 2 days after filing with the court, I got a call from the county clerk. The hearing was scheduled for the following Thursday. That gave me 6 days. I planned to use every minute. First thing I did was call Marcus back. "Think we'll need more than the deed and survey?" He didn't hesitate. "Absolutely. We need witnesses, records of prior ownership, and any communication from the HOA that suggests they've acted on this belief before. If they've tried this with other homeowners, we need them on the record." That night, I walked the neighborhood with a notepad and a list of addresses from the assessor's database. I knocked on doors, introduced myself, and asked one question. "Has the HOA ever claimed part of your property?" Most people looked confused. A few laughed. But 2 neighbors, Dale and Rosa, invited me in for lemonade and told me a very different story. "They tried that same stunt with us years ago," Rosa said, handing me a manila folder. "Said our dock was on common use shoreline. We paid for a lawyer and shut it down fast, but they never put anything in writing. They just stopped bothering us." I asked if they'd be willing to testify. "Gladly," Dale said. "About time someone held them accountable." Next morning, I headed to the county recorder's office where I requested every plat, easement, and amendment ever filed on my parcel and the surrounding lots. I found no evidence of shared shoreline rights, no HOA claim, not even a hint of community access language. The only thing I did find was a thin folder labeled Lakefront Meadows Articles of Incorporation, dated 16 years ago, and inside it, something that made my stomach turn. A single page stapled to the back, a map hand-drawn and unapproved outlining proposed community shoreline access points. My dock was circled in red pen. I scanned it and sent it to Marcus. His reply came within minutes. That's not a legal document, but it might explain their motive. If they've been operating off a fake map, we might be dealing with fraud. Later that afternoon, I checked my mailbox and found another note, this one typed and official-looking, printed on HOA letterhead. It was a fine, $500. Reason? Obstruction of community shoreline. I stared at it for a solid minute before walking it straight into the sheriff's office. Deputy Lawton, the same one who had responded to the trespass call, raised his eyebrows when I handed it over. "They're issuing fines now?" he asked. "Trying to charge me for blocking off my own property." He shook his head. "That could qualify as attempted extortion, depending on how far they take it." I let him make a copy, then added the letter to the growing binder I was building for the hearing. Every page was time-stamped, organized, and ready for scrutiny. The real surprise came the day before court when Marcus called and said, "I just got off the phone with the county prosecutor. He's opening a preliminary investigation." I stood up so fast I knocked over my coffee. "Into what?" "Unlawful attempts to seize private property. If the HOA board knowingly acted without authority and tried to enforce it anyway, that's abuse of power. And if they collected any fines under false pretenses, then it's criminal," I finished. Exactly. Thursday came fast. The courtroom was modest but packed. Word had spread. I saw Dale and Rosa in the gallery, along with a few other neighbors I'd spoken to. Brielle entered with 2 board members and a lawyer who looked like he'd rather be anywhere else. The judge, a no-nonsense woman with silver hair and a voice that carried, opened the session by asking for opening statements. Brielle's attorney stood and launched into a speech about tradition, historic access, and community cohesion. He cited vague references to neighborhood expectations, but couldn't produce a single legal document to support the HOA's claim. Then it was our turn. Marcus laid out the facts: the deed, the county survey, the original plat map, and the lack of any recorded easement or shared access clause. He showed the judge the fake map from the incorporation packet and explained how the HOA had used it to justify their actions. Then he dropped the hammer. "We have video evidence of the HOA president and board members entering Mr. Granger's property without consent, removing private fixtures and issuing fines based on fabricated authority." He played the footage. The sound of Brielle's voice, declaring the dock reclaimed, filled the room. The judge didn't say a word, just stared at the screen and then at the HOA table. Next, Dale and Rosa testified. They described their own experience, how the HOA had once tried the same tactic and then backed off when challenged legally. The judge finally turned to Brielle. "Do you have any documentation recorded with the county that indicates your association has rights to this shoreline?" Brielle stood, clearly rattled. "The community has always answered the question. No. But the board has operated under the assumption. The law doesn't operate on assumptions, Miss Redding." The judge recessed for an hour. When she returned, she didn't waste time. "Based on the evidence presented, I find that the property in question is legally and exclusively owned by Mr. Granger. The HOA has no authority over it, and any attempts to enforce control were without legal basis." She turned to Brielle. "The court advises the county prosecutor to proceed with further investigation into the board's conduct." Then she looked at me. "Mr. Granger, your rights as a homeowner stand. You are entitled to pursue civil damages if you choose." Applause rippled from the gallery. The judge banged her gavel once and stood. As the courtroom emptied, I saw Brielle storm out, her lawyer trailing behind her. She didn't look at anyone. Outside, Marcus clapped me on the shoulder. "You just made case law in this county." "That dock is more than yours now, it's a precedent." I exhaled for the first time in days. "Let's hope the next guy doesn't have to go through all this just to enjoy his own backyard." Marcus nodded. "He won't, not after today." And just like that, the lake was mine again. By the following Monday, the lake was quiet again, at least on the surface. Brielle's reign had been publicly dismantled, but something about the way she'd left the courthouse didn't sit right with me. She hadn't argued, she hadn't protested, she hadn't even looked surprised. It was as if she already had a plan B. 2 days later, I found out what it was. I got a call from a woman named Deidre, a CPA who lived up the road. I'd only met her once briefly at a neighborhood cleanup event. She sounded tense. "I don't know who else to talk to," she said. "I've been the HOA's volunteer accountant for the past 6 years, but I just quit. You need to know what they've been doing." I invited her over that evening. She arrived with a battered laptop and a folder that looked like it had been through a wind tunnel. She didn't waste time. "They've been siphoning maintenance fees into a discretionary fund. It's not listed in any of the public budgets. Brielle calls it the board initiative account, but I traced several payments: landscaping, plumbing, even a dock repair, none of which ever happened." "How much are we talking?" I asked. Deidre pressed a key and turned the screen to face me. "Almost 60,000 over the last 4 years. All miscategorized. I think they've been laundering it through a shell vendor." I felt a chill crawl up my spine. "Do you have proof?" She tapped the folder. "Invoices, check stubs, internal emails. And the kicker, the vendor they've been using, Green Ribbon Property Services, doesn't exist." I cross-checked with the state registry. It's not even filed as a business. I sat back in my chair and exhaled slowly. "You realize what this is?" She nodded. "Wire fraud, embezzlement, possibly even tax evasion if they reported it to the IRS." I called Marcus again and explained everything. He told me to make copies of everything, digital and physical, and bring them to his office that night. He'd contact the state attorney's office in the morning. The next day, a pair of investigators from the Financial Crimes Division showed up in unmarked suits with a warrant. They spent 3 hours in the HOA's clubhouse, walking out with 2 desktop towers, a filing cabinet drawer, and a printer. That evening, Brielle's name hit the local paper's front page. Not just as HOA president, but as a suspect under active investigation for misappropriation of community funds, falsified vendor contracts, and unauthorized financial withdrawals. But still, something wasn't adding up. The fraudulent shoreline claim, the fake map, the secret account, it all pointed to something bigger than just opportunism. I started digging into the HOA's original filings again, hoping for a crack. I found it in an old zoning appeal from 8 years ago, buried in the county's archives. The HOA had petitioned to reclassify several lakefront lots, including mine, as community access zones. The appeal had been rejected. But someone had still drawn up the map and started treating it like gospel. That petition had been filed by someone named Todd Redding. I stared at the name for a long time. Not Brielle. Todd. I asked Marcus to run a background check. What he found changed everything. Todd Redding wasn't just Brielle's husband, he was also the founder of Green Ribbon Property Services. The vendor that didn't exist, except it had existed briefly. It had been registered under a different name 6 years ago, operated for 11 months, then dissolved. Afterward, Brielle began billing the HOA under the same name but never re-registered it. No tax ID. No address. Just a mailbox at a UPS store. They'd been funneling money into a defunct company's name and collecting through a personal account. The state moved quickly. Todd was arrested 2 days later at a storage facility in the next county over. They caught him emptying a unit filled with HOA documents, bank statements, and 3 safes. He was charged with wire fraud, tax evasion, and destruction of public records. Brielle turned herself in the following morning. Her mugshot was on the evening news by dinnertime. At the next emergency community meeting, the clubhouse was standing room only. An interim board had been appointed by the county through a court order. Deidre was named acting treasurer, and I was asked to serve as a temporary oversight liaison. I wasn't thrilled about the title, but I wasn't about to say no. "We're not here to relive what happened," I said during my first address. "We're here to rebuild what's been broken. That starts with transparency." Over the next month, we held open-book financial reviews. Homeowners who'd been fined for non-existent violations were refunded. Some had been wrongly charged thousands for compliance inspections that never occurred. Every dime was accounted for. Every vendor was verified. Every new expense was publicly posted online, but the fallout wasn't over. A group of homeowners filed a civil suit against the former board, seeking damages. Marcus helped them organize a class action claim, and I provided the evidence. Depositions started in early fall. One morning, I got a letter from the Department of Justice. They were opening a federal inquiry into small community HOA fraud patterns in the state. My case had triggered it. The irony wasn't lost on me. I'd moved to the lake to escape chaos. Instead, I'd walked into a minefield of corruption, manipulation, and buried crimes. But now the water was still. The community was healing. One evening, as I sat on my dock watching the sun dip behind the trees, Dale wandered down with a couple of beers. He handed me one and sat beside me without a word. We watched the sky shift from orange to violet. "You think they'll see any real time?" he asked eventually. "Probably," I said. "State's building a solid case and there's federal oversight now. They won't get to walk away from this." "Good," Dale said. "About time someone took a swing at these tin pot tyrants." We clinked bottles and sat in silence for a while longer, the kind that doesn't need to be filled. For the first time in months, I could hear the lake again. Not just the sound of water lapping against the shore, but the quiet certainty that the worst was behind us. The lies, the threats, the power grabs exposed and dismantled. I didn't need a title or a podium. I had my home, my dock, and my peace. And I'd made damn sure no one would ever try to take them again. The county's audit team moved in quietly, but their presence rippled across the entire neighborhood like a dropped stone. Black sedans parked outside the HOA clubhouse. Suits with clipboards were seen taking inventory of every remaining document. Then the clubhouse was locked up, sealed behind yellow tape, and a sign that simply read, "Under investigation, do not enter." The interim board, still reeling from the financial revelations, was suspended pending the outcome of the investigation. They hadn't been directly involved in the fraud, but the state didn't want to take chances. Instead, a court-appointed fiduciary firm took over HOA operations. The neighborhood's fate now rested in the hands of professionals who answered only to the county and the court. I thought I might finally get some peace, but less than a week later, I discovered how deep the previous board's crimes really went. It started when I got a call from an investigator with the State Department of Real Estate. He asked if I had a few minutes to answer questions about the HOA's enforcement practices. I agreed, thinking it would be a simple follow-up. But within 10 minutes, I found myself standing in front of a storage shed behind the clubhouse with 2 officers and a real estate compliance agent named Voss. He was tall, sharp-eyed, and had a habit of rubbing his temple whenever someone tried to dance around facts. "We're looking into property records," he said, gesturing to a stack of water-damaged boxes they just pried from the shed. "It appears your former HOA president may have filed fake liens against multiple homeowners over the past few years." I stared at him. "You're telling me they forged liens?" "In at least 9 cases, yes. Possibly more. The liens were designed to pressure homeowners into selling under market value. Some residents moved out within months of receiving the notices." A deputy opened one of the boxes and held up a file. Inside was a photocopied lien with a forged notary stamp identical to one I'd seen in the file Dale had briefly shown me weeks earlier. Only now, it wasn't an isolated case. It was a pattern. Voss exhaled through his nose. One of the properties was sold to a shell company. That shell company transferred ownership to Todd Redding 6 months later. I didn't speak, just stared at the papers in his hands and wondered how many neighbors had been quietly run out while the rest of us were kept distracted with fines and fence paint. That same day, subpoenas were issued for every transaction connected to Todd or Brielle Redding in the past 5 years. Their bank accounts were frozen. Their assets, including a rental cabin upstate and a lakefront boat they never registered, were seized. 3 former residents came forward with affidavits. One of them, a retired schoolteacher named Maureen, described being told her house was in violation due to emergency zoning changes, and that the fines would accrue daily unless she sold. She moved out within 30 days, terrified of losing her retirement fund. The fraudulent lien was found in one of the boxes, stamped and signed, but never filed with the county. That's straight-up racketeering, I told Marcus when I brought him up to speed. They weren't just stealing from us. They were flipping homes they illegally forced people to abandon. He leaned back in his office chair, eyes narrowed. This is bigger than an HOA scandal. It's organized fraud under the pretense of community management. If the DA pursues RICO charges, they could be looking at decades. The district attorney did exactly that. 2 weeks later, formal charges were filed. 37 counts ranging from wire fraud and forgery to racketeering and elder coercion. The Reddings were denied bail. The court deemed them a flight risk after authorities discovered they'd purchased burner phones and booked a cruise under false names shortly before the investigation began. The community meetings became something else entirely. Not gatherings for updates or neighborhood concerns, but support groups for those who'd been manipulated, harassed, or outright robbed. Some residents had paid cash to the HOA for emergency repairs that never happened. Others had been threatened with legal action over imaginary violations. One woman, a nurse named Kendra, stood up during a meeting in the park and revealed that she'd been fined over $1,000 for unauthorized medical equipment after installing a ramp for her wheelchair-bound husband. She'd paid it out of fear they'd lien her home. People listened. People cried, but more importantly, people united. With the former board disgraced and the HOA under state supervision, the neighborhood began to change. The fences that had once divided us turned into conversation spots. People who'd never spoken before started exchanging phone numbers, helping each other repair damage and organizing potlucks in front yards instead of behind hedges. The state's fiduciary team worked fast. Within 2 months, they froze all HOA accounts pending restitution. They offered amnesty to those who came forward with evidence, and they issued full refunds to anyone who could prove they'd been falsely fined or coerced. And then came the best part. The judge overseeing the civil case handed down a final ruling. The entirety of the HOA's discretionary funds would be liquidated and redistributed to the victims. The Reddings' lakefront assets, including the unregistered boat, were auctioned off. The proceeds helped fund a community improvement trust overseen by a neutral financial firm. As for my property, the judge issued a separate ruling filed officially with the county and marked in bold. The property located at Lot 17, Lakefront Meadows, including all shoreline structure and dock access, is the sole legal possession of Everett Granger. No future claim shall be entertained by any governing association or individual under the jurisdiction of the Lakefront Meadows Homeowners Association. I had it framed and mounted in my living room. Sometime later, I got a letter from the DOJ. They were launching a nationwide probe into HOA overreach and fraudulent practices, using our case as one of the foundational examples. They wanted permission to use my footage, my court transcripts, and the evidence I'd gathered. I signed the release. One evening, Dale dropped by with his son to help me install a new motion sensor light near the dock. We didn't talk much about the case anymore. There wasn't a need. The air was different now, lighter. As we packed up tools, Dale glanced toward the water. "You ever think about running the real board?" he asked. "Once the court hands it back over," I laughed. "No thanks, I've had enough meetings and subpoenas to last a lifetime," he nodded, grinning. "Fair enough. Still, if you change your mind, you've already got the lake on your side." The sun dipped low, casting amber light across the dock. No patrols, no clipboard-wielding tyrants, just still water and a breeze that didn't carry the weight of surveillance. For the first time since I'd moved to Lakefront Meadows, it felt like a neighborhood again. Not a gated fiefdom, not a boardroom war zone, just a place where people lived and looked out for each other. As I stood there, looking out over the lake, I realized something. They had tried to take more than my property. They tried to take my peace, my autonomy, my right to say no without fear, and I'd taken it all back. Every inch, every right. Every quiet morning on the water, not because I wanted a fight, but because I'd refused to lose my home to the illusion of authority. And now, with the lake stretching out before me, I knew one thing with absolute certainty: they'd never get another chance.